no jail, no probation, no penalties at all, other than he'll be convicted now. You just keep filing this crap, I don't even care. I'm not even reading it. Denied. Trump seeks review of two closely related, interlocking, erroneous decisions by Judge Merchan, denying Trump's claims of immunity. Now, the judges in New York want Trump sentenced so badly, and they said, let's have a hearing right now. Trump's sentencing is still on, scheduled for Friday, the 10th. Here's what happened today. People of the state of New York versus Donald Trump. This is the Judge Merchan case, the false business records case that brought out Stormy Daniels and convicted perjurer Michael Cohen. And this is Alvin Bragg's opposition. So yesterday on the show, we read through Trump's defense motion saying, Judge Merchan, you cannot sentence us because of presidential immunity. Presidential immunity means you're immune from the process, not just from the outcome, but you cannot go through the process. So what we see right now on the screen is Alvin Bragg's response. Trump said, you cannot sentence me. Alvin Bragg responded and said, the court should deny Trump's request to stop the sentencing hearing, saying, as is clear, pre-trial immunity could foreclose an unnecessary trial, but we've already had a trial, okay? The case is already done and closed. And you've already explained, Your Honor, that you're not going to even sentence him to jail. You're going to give him a total discharge, so no fines, no jail, no probation, no penalties at all, other than he'll be convicted now, and he'll be a convicted felon, which by itself imposes certain penalties. So he says it's an unconditional discharge, so there's no risk of an extended proceeding or any of those things. Nor should the court grant a stay and stop the sentencing because this weighs in favor of the people. We want prompt prosecution. We want finality of criminal proceedings, the standard stuff that you'd expect from a prosecutor. And the current schedule's entirely a function of Trump. We're sorry that we have to sentence him right before his inauguration, but we have to because he asked for additional time back before the election. And that's right. Trump did say you should postpone this until after the election. And now they're saying, you want to postpone it again? Well, we did postpone it. We got what you wanted there, Trump. So now eat the sentencing. They say Trump has already advised the court he's going to appeal these things, and we're going to look at that because he's done that, and says there's no real immunity here. Now, we can fast forward because the judge already ruled on this. Here's what Merchan said in response. All right, by the affirmation of Todd Blanche and the accompanying memoranda of law dated January 5th, Trump gave notice. Specifically, Trump notified this court that he's going to initiate appellate proceedings on January 6th to challenge our orders. Trump also claims that commencement of these appellate proceedings immediately results in an automatic stay of these proceedings. Now, in the alternative, they say, if you don't automatically stay this, then we ask you to do it by your choice, by discretion. So by memo stated and dated on January 6th, Alvin Bragg, the motion that we just looked at, they oppose an automatic stay. They say, no, Trump can appeal if he wants to, but it doesn't automatically stay this case, meaning the sentencing stays on. In support, they submit that the equities, if you just balance what the people need, what the people want versus what Trump wants and what Trump needs, they tip in the people's favor. And Trump is not going to be harmed if we sentence him. They also say that Trump is not going to win on any appeals. And they know that probably because, of course, they're in New York. Now, this court has considered Trump's arguments in support of his motion and finds that they are, for the most part, which is like a joke, a repetition of the arguments he's raised numerous times in the past. Okay, well, what about the other part? Because you're not going to get to it in these like 4 sentences that are left, including in criminal law, the motion to vacate his conviction and another Clayton motion, which is another motion to dismiss. He's like, you just keep filing this crap. I don't even care. I'm not even reading it. Denied. So further, this court finds that the authorities that are relied upon here are also factually distinguishable. So the cases that you're citing that you say I have to follow are not even important. No, they don't even matter here. So therefore, Trump, your motion for a stay of the upcoming sentencing scheduled for this Friday on January 10th is denied. So your sentencing will be on. And now, of course, the judge has already said that he's not going to sentence him to jail or probation or fines or any of that stuff. But that's just his word. And nobody trusts this guy because he's a corrupt hack who lies about his daughter and gags everybody who want to talk about it. He says, as he wraps this up, nothing in this decision shall preclude Trump for appealing. If he wants to appeal, he can go ahead and appeal. That's fine. This is the decision and order of of the court. And so Trump can appear by Zoom if he wants to, or he can walk right in there and look at Juan's disgusting face right in his eyes. And we'll see what the president does or what his team decides to do. But one thing they did do is they filed a notice of a petition. They filed an appeal up to the Appellate Division in New York. And this came out 9:30 this morning, fresh out of the oven. They're moving fast on this. But here's what Trump's people are saying to the corrupt New York court system. They say, all right, listen, we are now appealing this. Here they are denials by the lower court judge, Merchan, acting judge, of Trump's official acts immunity. We have absolute immunity of a sitting president and a transitioning president under the Supreme Court precedent and under federal law and under New York law. And so we're appealing this to you. Signed by Todd Blanche, incoming Deputy Attorney General, and the Assistant Deputy AG, Emil Bove. Copied to Matthew Biden's prosecutor, Matthew Colangelo. Here's what they say. All right, listen, Court of Appeals. Trump is now appealing this to redress the serious and continuing infringement on his presidential immunity and criminal process as he transitions in as the 47th president. In this petition, Trump seeks review of two closely related, interlocking, erroneous decisions by Judge Merchan denying Trump's claims of immunity. One, on December 16th, he said Trump doesn't have any presidential immunity based on the evidence that was presented at trial that they'll get into. And then two, the recent decision just days ago where he denied Trump's post-trial motion that said he also doesn't have immunity now as he's transitioning into the presidency. These are errors. They are violating Trump's fundamental due process rights, and they're resting on the testimony of a disbarred, disgraced, serial liar called Michael Cohen, convicted perjurer, saying Judge Merchan's terrible and erroneous decisions threaten the institution of the presidency. They run squarely against the established precedent, disallowing any criminal process against a president-elect, and they are violating the prohibition against the use of presidential official acts in a criminal prosecution. And so under Trump, the Supreme Court case, under the Supremacy Clause, under the Constitution and other law, including the New York Constitution, Justice Merchan is without authority under the law to proceed to sentencing, while Trump exercises his constitutional rights to appeal and to vindicate the erroneous jury verdict. And so everything here must be dismissed without delay right now. They tell us Trump is going to be the 47th president of the United States. Merchan is the acting justice of the Supreme Court. Alvin Bragg, we know, is Alvin Bragg. And a lot has happened here. In fact, in February, the U.S. Supreme Court accepted the Trump immunity case. Within a week of that, Trump moved to exclude, back at the lower court, all of Trump's official acts at trial, saying you cannot talk about those. That is immune. Judge Merchan didn't care. Trump specifically challenged several pieces of evidence that were shielded by Trump's immunity, including his ex posts where he communicated to the American people through that. Judge Merchan denied everything. He cited a bunch of garbage. He declined to consider whether immunity precludes that evidence, right? And he wrote that. They're citing that for us. Then on April 10th, Trump filed a petition up to the higher court. They said, you know, the lower court judge is terrible. And that came back down. They denied the petition. The court said, you may raise your issues of immunity on a direct appeal. That's what we're doing right now. So we're doing what you told us to do. On April 15th, then, the first day of jury selection, Alvin Bragg made an offer of proof of official acts of President Trump while he was in office. Trump again objected, said, I'm immune. I'm the president. I'm allowed to do those things. He submitted his objections to the judge, which included objections to statements made from his ex account and documentary evidence of his presidential actions. Then on April 19th, Merchan said that Trump would have to wait until trial. You can't raise those objections now. Raise those at trial. That runs against the requirement of Trump that those get resolved pre-trial. The Supreme Court said you have to review all of that before the trial starts so that we can rectify it before the jury gets impaneled. Thus, Justice Merchan violated the doctrine right there. Then we had the trial. Throughout the course of the trial, Trump renewed his objections. I object, I object, I object. Trump elicited objections, and the trial brought out lengthy testimony about Trump's official acts. For example, Alvin Bragg got testimony from former White House Communications Director Hope Hicks. Hicks joined Trump's administration in 2017, and her official duties were helping with Trump's agenda. She came in and testified. She worked in close proximity to Trump. Her duties included coordinating communications, directly with the president. At trial, they asked her specifically about this. Her official communications with Trump about the Wall Street Journal article that was brought into evidence by Alvin Bragg. She says, I spoke with Trump about how to respond and about a team response. All of that was Trump communicating with his employee, a government person from the White House. Hicks also testified about her communications with Trump about a New York Times article that was referencing Michael Cohen's payments. She said, I did speak to Mr. Trump. I was the communications director. So this was a major interview. Yeah, we just spoke about the news coverage of the interview and how it was playing out. They also brought in another official witness who worked with Trump called Madeleine Westerhout, special assistant and executive assistant to the president. She came in, talked about details from the White House, including invasive testimony about all of this, work habits in the Oval Office, and more. All of it official conduct that they brought in. During trial, they also talked about his X account, Twitter at the time. They offered evidence about his official actions. During closing arguments, they repeatedly talked about official acts immunity from Hicks and others. Then on May 30th, the trial concluded. The United States Supreme Court, on July 1st, issued its decision in Trump versus United States. One day after the trial concluded, Supreme Court comes back out and says, oh yeah, I got immunity. The court held that the president has absolute immunity for his core constitutional powers. These are the three buckets we talk about. At least presumptive immunity for other things that are within his outer perimeter. So absolute, presumptive. And then the third category is no immunity. The court held that the doctrine of immunity prevents the evidentiary use of official acts against a president. They just did that multiple times. We gave the examples. After the decision, Trump went back and gave Merchan the legal backhand and said, hello, you have to set this aside. Then we set a briefing schedule and more. Trump then filed a detailed motion to vacate the jury verdict, says you relied on illegal evidence and you can't use it. Merchan then denied Trump's motion. Now his order was wrong. He conceded that many of Trump's claims were properly preserved. Yeah, all of those objections were there. He wrongly found that other claims were unpreserved because we made objections 170 times during this. And then Merchan disregarded the Supreme Court. They had a strict instruction back to him. All right, listen, Judge, questions about whether the president may be held liable for actions must be addressed at the outset of a proceeding, not at the end. They focused improperly on objections and waivable this, that, and the other. He erroneously held this judge that none of the evidence about the White House Hope Hicks testimony was covered. No, that's not immune. He gave no weight to her. She had an official role at the White House. He didn't even care. He declined to follow the Supreme Court. They told him it forbids testimony from his advisors. You don't get to probe the official act with highly intrusive inquiries and go into Trump's motive. That makes you the president. You don't get to substitute your judgment for the president and say, well, maybe he shouldn't have had that conversation with his close advisor or whatever. That's their branch, not yours. In particular, these communications involved public concern to the American people. And Merchan committed another error when he allowed Madeleine Westerhout, her testimony, to come in. She was a close advisor. They were asking her about sensitive internal discussions here. And Merchan also erroneously found that none of Trump's postings on X were official acts, which is ridiculous. In so finding, he said, well, some of those tweets don't fit the mold. They're entirely personal and there's no policy concern or public interest. Yeah, this is despite the fact that we know that Merchan hates Trump's tweets and X postings because his daughter was telling her podcast co-host about that, saying, my dad doesn't like when he tweets. And it's on recording. We have it. Merchan declined to follow the clear instruction in Trump that most of his communications are likely to be immune or at least within the outer perimeter of his official responsibilities and therefore presumptively immune. Public communications through White House social media accounts and employees, those are clearly presidential acts. Here, Trump possessed actual authority to speak on behalf of the executive branch, and he was addressing concerns of the American people. Now, Merchan reasoning that Trump's decision were permitted, saying that his strict instruction of these things, if Trump were not allowed to post on X, then it would chill the president's willingness to communicate with the public if now all of those things are suddenly not official. And you can be prosecuted and that can be used as evidence against you for promoting policy ideas. Merchan incorrectly found that the evidence of Trump's statements on forums were not official. And so they did everything they could and made a number of errors in saying that none of this was official. He also wrongfully found that the admission of official acts was harmless. Well, maybe some of it was official, but it was harmless. He found evidence presented to the grand jury did not consist of official acts. He said, no, they're just personal conversations. He relied on his previous findings. He violated articulated the doctrine of presidential immunity. He admitted extensive testimony about Trump's conversations with his cabinet. At trial, Alvin Bragg presented a 2018 text message from convicted perjurer Michael Cohen, who was working for Trump, indicating that Trump had approved Cohen addressing an FEC complaint. Okay, that's Trump's official actions with his attorney. Contrary to Justice Mercan's erroneous decision to admit those statements, he said they can come in even though they're within the outer perimeter, at least arguably the outer perimeter of his official responsibilities. Cohen also testified that Trump told him that the FEC inquiry would be taken care of by Attorney General Jeff Sessions. And even if that is a conversation that happened, that's a conversation about official business. All of it got admitted. They say, look, even if this conversation had happened, which we don't concede, even if you believe convicted perjurer Cohen about that, his testimony is explaining presidential action, and you allowed that to come in. So the judge abused his discretion. Now, during the trial, perjurer Cohen also sought to justify his perjury before Congress and Trump's public statements about the special counsel investigations as well. Now, moreover, power of the presidency includes the authority to communicate to the people. That's kind of why you're there. And Bragg also elicited testimony from Cohen about the power of the presidency, about how he would back channel things. And so then Trump got reelected. All right. The jury came in, they found Trump guilty, and all of these things should be reversed. So then what happened next? All right. They're giving us a timeline. On November 5th, Trump got reelected, landslide. Once Trump became the president-elect, we've got 75 days of a crucial time. A sitting president is shielded, and Trump, as a transitioning president who's coming in, is also shielded. Alvin Bragg even admits, once Trump assumes office on the 20th, the underlying criminal case against him is stopped. Justice Story talked about this. Sitting president immunity protects Trump now. And this goes all the way back through multiple cases. And so once a president assumes office, any criminal cases against him must be dismissed. And sitting president immunity also shields the president-elect, because that is now an official position. The federal special counsel's office even agrees with us. They agreed with the reality of that. Jack Smith dismissed his January 6 case and lost his Florida classified documents case. In fact, the Presidential Transition Act, Congress emphasized the continuity and identity between the transitioning president and the current president. Lots of law there. The presidential nature is also recognized by President Kennedy and many others. The structure of the Constitution and the separation of powers means that it's like one person's handing the baton off to another. So Trump has become the incoming president, the elect. Any criminal sentence or even the distraction of ongoing criminal proceedings, including these appeals, including this sentence, threatens to disrupt the burdensome task of the presidential transition. Even the federal DOJ agrees. Now, the president-elect must immediately begin addressing all of the important things. Their complete engagement and undivided attention must be focused on their job. There's also public stigma, which is really what they care about most. They need Trump to be a convicted felon, and this is their last gasp to get it done. Indeed, the severity of the burden imposed upon the president is happening now. And once again, the same reasoning applies now. We don't want to stigmatize the incoming president with the burden of criminal prosecution. And during the transitional period, he must communicate with world leaders, select key personnel, and do many things. Making the president focus on this undermines the institution of the presidency. And we don't want our own country to do that to itself. Third, the mental and physical burdens are also taxing. Defending criminal litigation here, especially at sentencing, is extremely taxing and burdensome. These demands of time and energy drain and disrupt the presidential transition. Sitting president immunity requires you drop this. Permitting prosecutors to leave an indictment against a sitting president pending during his term in office would play Russian roulette with America's vital interest and its national security. And so, given the realities of modern politics and mass media and the delicacy of political relationships around the world, there would be a Russian roulette aspect to the course of indicting the president but postponing trial, and that came from an OLC memo. That is from the Office of Legal Counsel, even before Trump was anywhere on the political scene. Trump already argued this should be dismissed. On January 3rd, Merchan entered an order erroneously denying the dismissal. He acknowledged that a sitting president is immune. That's why they have to cram this in on the 10th. But he erroneously said that it doesn't apply now, but it does. His entire analysis is erroneous, says Trump. It relies on case-specific application of certain factors, but the analysis is obviously wrong and an abuse of discretion. He only asks whether those three factors would prevent a significant obstacle, but that's not what the Supreme Court said. His analysis is wrong because it directly contradicts the reasoning of the very memo that he is citing. The memo says that the presidential immunity doctrine does not depend and must not depend on a case-by-case analysis. We don't do that. It says it's categorical, okay? If you're the president or incoming president, you are not subject to a case-by-case basis of balancing whether some hack prosecutor like Bragg and Colangelo can bring a case. That's not how this works. That's what the Supremacy Clause is. This case-by-case basis is wrong as a matter of law. Even the Office of Legal Counsel and the insane DOJ agrees. And so now we are petitioning for a reversal of Merchan's orders. The Constitution and the framers want this system in place. That's why we have immunity and these concepts. And so, citing a lot of law, they say Bragg unconstitutionally elicited testimony from Hope Hicks, said that they spoke every day. You can't do that. You can't bring in testimony from advisors. It's highly intrusive. You can't judge what the president is doing. That makes the prosecutor and the judiciary subject to an interference in the executive branch. It's a separation of powers problem. Trump's internal deliberations about the White House response are absolutely immune. He was supervising somebody who was wielding executive power on his behalf. That's Article 2, absolutely immune conduct. And Trump was also communicating with the American people, absolutely part of the presidential role, using X to do it. And Judge Merchan's failure to appreciate the seriousness of this doesn't mean that the evidence comes in. Because Trump's statements were plainly within the outer perimeter of his authority, it should have never been admitted. Merchan completely ignored the critical issue the Supreme Court told him to review. And even more important, they failed to appreciate what they've done. And what this has done is created a dangerousness to the entire institution of the presidency. And so the appeal continues on, and we'll just hit the highlights of this because the order coming back down was quite short. The use of the official act's evidence requires dismissal. You brought in illegal evidence, and the verdict needs to be dismissed. Trump's immunity is mandated because he is now president-elect, and Merchan is causing irreparable injury to Trump and to the entire country with his lawfare lunacy. By allowing these criminal proceedings to continue in violation of Trump's constitutional rights to presidential immunity, this is committing irreparable harm upon President Trump. And so therefore, Trump respectfully requests that this court grant judgment in his favor as follows. Find that the continued criminal proceeding is unconstitutional and unlawful. Direct the case and the jury verdict in the underlying case to be vacated and immediately dismissed, and any other items as deemed appropriate and proper. Signed by Blanche Law. Now that filing is a good one. It's 502 pages. You can see a bunch of exhibits from all of the other filings, his affirmation and his other motions. We objected. This is what we've done. And it goes on for 500 pages. So you can see 9:30 in the morning. Now, the judges in New York want Trump sentenced so badly that they threw everything off their desks today and they said, let's have a hearing right now, because they need him to be a, quote, convicted felon according to garbage New York law. So they did that. There was an oral argument that took place today. Adam Klasfeld was there inside reporting, and he said an appellate hearing is about to begin in New York over Trump's efforts to overturn his guilty verdict and block the upcoming sentencing on Friday. Here's what happened. Judge came out. Do you have any support for the notion that presidential immunity extends to presidents-elect? Well, he's like not the president yet, you know. Todd Blanche says, well, Your Honor, no. There is no case law for this, because this has never happened before. We've never had hack losers like Alvin Bragg and Matthew Colangelo do anything like this, or disgusting judges like Judge Merchan enable it to this extent before. So no, I don't have any case law. Sorry, it's never happened before in American history. Thanks. Judge says, oh, well, you don't have any case law then, so I guess you're going to lose. So he continues to report. He tells us, Stephen Wu for Alvin Bragg's office comes up. Your Honor, I mean, the theory of president-elect immunity is inconsistent with the fact that there is one president at a time. He's like, wow. Everybody in the DA's box was like, oh, brilliant. One president at a time. Such a great argument. You're so smart. Thank you, Stephen Wu. What a genius. And the judge is like, yeah, that's a great point. That's really smart. It's true. So then the judge says, Stephen Wu says, Your Honor, there's also an omnibus motion for Bragg's office, because Alvin Bragg can't argue anything. Did not raise a general claim of immunity, only claiming that certain evidence was related to official acts. He says, so this is a case where criminal charges and convictions are related to unofficial acts. So there was no official acts business, Your Honor, at the Court of Appeals. And so nothing was wrong. He says, the appellate judge, Your Honor, and you can trust Judge Merchan because they flow from his understanding of the constitutional landscape after Trump gets back into the White House. Oh, gosh. Trust Judge Merchan? You mean the judge that made 2 donations to Joe Biden? I think 3 of them, actually. To Joe Biden and anti-Trump organizations? That judge? The same judge who is so upset about Trump's tweets that he rants and raves like a maniac so loudly that his daughter hears it and is so concerned for him that she brings it up in a podcast. Like, even my dad hates it. Your dad's a judge, so maybe you should watch that. But in addition to that, the judge's daughter works for Democrats and helped them campaign and raise millions of dollars. Then the judge, because he's so guilty, gagged Trump from talking about it because he knows if Trump talked about it, he'd be busted big time. You only gag people when it's true. We all lived through that back during COVID. We all got censored back when it was all true. So Klasfeld says that the reporting continues. Over the appellate hearing, a fault line has emerged over Judge Merchan indicating that he was leaning towards an unconditional discharge without jail, fine, or probation. Todd Blanche, Trump's defense team, Your Honor, I don't care what he said. The judge's non-binding intention, he's not going to fine him or jail him, he's still going to convict him and sentence him, and there will be penalties associated with that. For example, will Trump be able to vote in 2022 if they do this? Alvin Bragg's office says, oh, Your Honor, that's ridiculous. You can trust Merchan's remarks, okay? He understands what's happening, and he's going to do what the Constitution abides. Trump's attorney, Todd Blanche, comes back and says, there was a skeptical reception in the appeals court today, and we got the judge's decision, and here it is. Court of Appeals heard oral arguments, read through Trump's entire motion, got the useless counter arguments from Alvin Bragg's Stephen Wu, who's like, Your Honor, there's one president at a time. Great job, Steve. And now they say, it was brilliant, amazing arguments. Trump, you lose. You're getting sentenced on Friday, so just sit there and take it. We don't care that you're the president-elect, the incoming president. We don't care that the whole country vetoed our lawfare and reelected him. We're such sore losers and big whiny babies that we're going to do everything we can to get that label on you, because that's all they care about. They're label people. They have no meaning or purpose in their lives other than their labels. They think if they get the right label, that will make them a great person, but that is not how that works. So they're working hard. You can see this was submitted by Trump. The petition, this is the order coming back down. Here's the disposition. After consideration of the papers submitted and the extensive oral argument that all happened today, Trump's application for an interim stay is denied. And so Trump, as it stands right now, the New York judges colluded to insurrect a president who is transitioning into power, interfering with the peaceful transition, trying to sentence him using the courts to exact punishment and retribution on a duly elected official who was reelected in spite of all of this. So the judge who signed this is Ellen, probably Germer. So some judge signed that from New York, and the sentencing will be here happening on Friday as ordered, unless Trump's people submit something to the United States Supreme Court and ask them to step in, or just tell New York to shove it and don't show up. Now, I think that might actually make things a little bit more politically volatile and worse, because then they would issue a warrant, and I think that would actually serve them and feed them. But Trump and his legal team are probably preparing something to the Supreme Court right now, if I had to guess, and we're going to be here to see what it is when it drops. Thank you for subscribing and joining as we do.